everyone. Thank you for tuning in today. Welcome to It's Time for More Injury Funding, the podcast for all who want to learn about legal funding and its significance in the personal injury, workers' compensation, immigration, medical malpractice, and many other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. In today's episode, we're honored to have Andrew Pickett, a well-known personal injury trial lawyer based in Melbourne, Florida, who has transitioned from being a criminal prosecutor to a leading personal injury attorney. Today, we will explore key aspects of personal injury cases and effective advocacy. At the end of our episode, we'll have a fun power question for Andrew, so stay tuned till the very end. Andrew, thanks for joining us.
Thank you. Thanks for having me.
Let's start our conversation with your journey. What made you decide to leave criminal persecution?
So I started as a prosecutor. This was my first real job after law school. And I did that for 4 years. And I didn't know at the beginning whether I wanted to do that for my whole career. But it was really fun because we got to try cases and be in the courtroom all the time. But I had to make a decision at some point, was I going to do this for my whole career or not? And so what I was looking at the time, I was in my late 20s, and I was thinking to myself, do I want to be a career prosecutor? So I looked at other of my coworkers who had been there for 25, 30 years, and a lot of them had become pretty jaded with the legal profession. And I think that's kind of a natural consequence of being in criminal law and seeing a lot of bad stuff and bad people for a long time. And so I knew that I didn't want to become jaded like many others. And also, I think that the legal aspect of criminal law, you kind of master it pretty quickly. And there's not really much variety in the legal challenges on the criminal side. So the civil side presented kind of a whole new area of law that provided me with some variety, as well as kind of the ability not to just be so narrowly entrenched in one area, particularly one where I was so focused on like dealing with like kind of the bad parts of society on a daily basis. So I was looking for a new challenge and variety while still being able to continue on as being a trial lawyer.
That's a beautiful path to where you are now. I love it. Thank you for sharing your story. How does that background give you an edge in trial?
So I think being a prosecutor or being a public defender is the path for a lot of people who want to get into trial law. And I've heard people describe it as like the equivalent of doing a residency as a doctor, where you're just working a lot, you're getting a lot of hands-on experience, you're not getting paid much, but you're getting a lot of very practical experience early on. And so what it enabled me to do was to be in the courtroom literally every single day for 4 years and to really get in front of a lot of juries for trials. So I was there for 4 years, and over those 4 years, I had, I believe, 42 jury trials.
Oh, wow.
Which, yeah, if I wanted to get that in the private sector, that would take much longer than 4 years. Generally, I mean, there are some people who are on that kind of pace, but in general, doing 2 or 3 trials a year is a good amount in the civil realm. So I think what it gave me is confidence in the courtroom, the ability to be comfortable speaking in front of people, connecting with people. Because I practiced mostly in Brevard County, Florida, and that's where I was a prosecutor, I got to know the judges very well. And so that was another benefit to being a prosecutor. It also, not really directly related to trial law, but it helped me to develop my referral network, because a lot of the criminal defense attorneys that I had cases against have now become referral sources for me. So all of those things, the networking, the confidence in the courtroom, but most importantly, the trial experience has been something that has been huge for me.
And you are so well versed. It's amazing. You could really talk to, one-on-one like we do now, or you're in front of probably thousands of people and you would sound the same. Very very patient, very well articulated. And so I can only imagine how amazing you are during trials. I would love to attend one of those, hopefully soon.
Well, think maybe you can come watch my next one.
Yes, let me know. Let me know the day. So, Andrew, what's the best advice you received as a young lawyer?
So I remember when I was a young lawyer, it was during a CLE presentation, and the advice that the senior attorney gave to young lawyers was don't be intimidated when you're facing somebody who has a lot more experience than you, because you can close that experience gap by preparing. And so a lot of a lot of older attorneys don't take the time to prepare as much, or they don't have the time, or they tend to kind of shoot from the hip or wing it more.
Mm.
But the way that you can close the gap as a young lawyer is to out prepare your opponent. And I really took that to heart at the beginning of my career, and it's been something that's really served me well over the years. Is putting in the time and preparation so that I know when I'm going into a deposition or a hearing or a trial, I'm always going to be more prepared than the other side because I've worked harder. And even if the other attorney has been an attorney for 35 years or 40 years, I know that they haven't done the prep that I have. So I think that that was great advice for me. And that's advice that I would give to any young lawyers is close the experience gap with the amount of time that you use preparing.
Thank you for sharing that. And do you have any mentors from your past, that were examples in who you are now that you would like to mention?
Yeah, I mean, I have a lot of mentors. So I've actually thought about this. I have people who are mentors directly that they know they were mentors. And then I have people that don't even know that they're mentors for me because I haven't even met them yet.
Oh,
But
that's the best.
yeah, and so when I was getting into the criminal prosecution world, I had a mentor. His name is Roger Powell, and he was a federal prosecutor. And I watched him do some jury trials even before I started my career as a prosecutor. And that's when it really clicked for me that trial is where I was going to kind of find my place. So he was a good mentor early on. I had, when I was a prosecutor, I had an attorney named Rob Parker, who was it's called a felony division chief, who invited me to sit second chair on a first degree murder case with him. And that was in my first year of being a lawyer. And so that was a great opportunity for me. Um, Michelle Perlman was my boss as a prosecutor. She was great. My old employer, John Alpazar, was a great mentor. And then since I've started on my own, I've kind of looked to people on a more national stage as mentors. Mark Lanier is a really important mentor for me. I've met him several times and have been going to his Lanier Trial Academy, and I've learned a lot from Mark. Jerry Spence is somebody that has been very influential. I went through the Trial Lawyers College in Wyoming. Um, and probably a lot more people that aren't coming to mind right now. Keith Mitnick would be another one. He's done a lot of teaching. I've met him once, but I don't know that he knows that he's a mentor for me.
Oh,
So I think that was something important to me early in my career is to find a mentor. And when I was at the prosecutor's office, I had people who I looked up to. And then when I was transitioning to private practice, I wanted to find somebody who I could learn from. And so as I'm growing my firm and I have young attorneys, I'm really placing a lot of emphasis on the mentoring aspect because I think that can really accelerate learning. And I realize how valuable that was for me.
that is so amazing, Andrew, that you never stop learning. You look up to all these amazing individuals who make such a difference in our legal system, and you learn from them, and you continuously travel around the country, and it's just so applaudable. Um, let's talk about balance of, life and work balance. What's your take, if there's such a thing at all, on work-life balance in your profession? Being a personal injury attorney and firm owner, entrepreneur.
Yeah, so that definitely is a hot topic a lot of people are talking about now is work-life balance. And as an employer, I'm finding that a lot in the hiring process is that like that's really important for potential employees. I was actually at a mastermind group. This is a mastermind group that's done through Fireproof,
Mhm.
and one of the and the leader of this mastermind, his name is Bill Biggs, and he summarized this in a way that really resonated with me. And here's what he said. He said that in when and he also, in addition to doing the masterminds, he also operates a firm, and he says that during the interview process, they tell the applicants, "We do not believe in work-life balance." And he says that, and then he just pauses to see what the reaction is. But then he goes on to explain that the term work-life balance implies that work is bad and life is good, and you need less work and more life, such that they're always competing against each other. And so the way that he described it is something that I agree with as well, is that we want the work that we're doing and that we're giving to our employees to be work that is life-giving and that is energizing. And people shouldn't be looking at work as bad and want less of it. They should be coming to work with feeling part of a team, part of a greater purpose. And so instead of the term work-life balance, the term that Bill used and which I have adopted is this idea of a well-integrated life. And so what that means is that there may be times where you have to work until 8 p.m. to get ready for a hearing or a deposition, or you might have to work on the weekend to get ready for a trial. But on the other hand, there might be times where, I have an employee who needs to take the day off to spend with their kids, or, their child has a sporting event or a play and they leave at noon. And so it's kind of being flexible with that, recognizing that, you know, family life is important as well, but it's not one or the other. It's integrating the two of them. And so that's when I heard that articulated that way, it really struck me. And it's something that I think I've adopted in my law firm is, we aren't working 7 days a week, 24 hours a day, but at the same time, we're not getting anxious because it's 5 o'clock and we're supposed to be off at 5. We have to integrate those well such that we're able to have both of them like feed each other.
This is by far the best definition of work-life balance I've ever heard, Andrew. Thank you. Thank you so much.
You're welcome. And I want to credit Bill Biggs for that, but I think he formulated something that I really believe in.
I love it, and so you should listen when you get a chance to the episodes I've recorded with our common friend Jen Gore, where she talks specifically about that. So
Yeah.
I asked that same question, and it's interesting how people have different views, but hers was actually pretty similar to yours.
Yeah.
All right, let's dive into personal injury trials. What exactly is a personal injury trial?
So the trial is the culmination of the dispute between the two parties. So in a civil personal injury trial, on one side you're going to have the plaintiff, that's the person who's injured, and that's the person who I would represent. And then on the other side you're going to have the defendant, and that's the person who caused the harm. And so the defendant is going to be represented by his or her own attorneys, usually funded by the insurance company. And you get to the point of trial when you can't settle the case by an agreement. So you're asking the jury, people from the community, to decide what the value of the case is or what the liability is. And you're essentially, as the plaintiff or the defendant, you're putting the case into the hands of the jury for that decision because, for the past 2 years or more, the parties haven't been able to come to an agreement. So the trial is the ultimate culmination where the jury makes the decision.
Mm-hmm. What determines whether a case is settled or goes to trial?
Well, ultimately, it's the parties who are making the decision, and the plaintiff is usually being offered a settlement at some point during the process. So a case makes its way to trial when the plaintiff is not happy with the settlement offer that's being made by the defendant. And so one of the important things that we have to be mindful of as lawyers is that the decision to go to trial is ultimately the client's decision. And so Sometimes it's a really easy decision because the injuries are so catastrophic and the offer is so low that you've really got nothing to lose by going to trial. Or other times you have a very limited insurance policy and the insurance company has acted in bad faith. And the only way that you're going to get more than the insurance policy limits is to go to trial and let the jury decide. But there are other times when it's a much more difficult decision um, where you have an offer that is going to pay all the medical bills, put some money into the client's pocket, but they don't quite feel that it compensates them fully for their injuries. And their decision is go to trial and try to get a better resolution with the jury. But then you're also risking that the jury might give you less than the settlement offer. So those are the really hard ones to decide what's in the best interest of the client. And so as we, as lawyers, are evaluating these decisions and giving clients advice, what I tell clients is that I can never make any guarantees. We can only talk in terms of probabilities. And so for me to want to take a case to trial, I have to believe in the case myself, and I have to believe and credibly tell the client that we have a reasonable likelihood of a good outcome. But I can never guarantee an outcome. So the client understands at each stage what the risks are, and then ultimately it's their decision.
You mentioned Keith Mitnick. I went to one of his seminars here in Atlanta maybe 2-3 years ago, and he said, somebody asked the question, do you ever get any less anxious or nervous or excited before the actual trial? He said, actually, no, even though he's been doing this for 30, 40 years. What about you? Do you feel like you're getting less, nervous, or is that still the same with every single trial?
So I still get nervous when I'm in trial. But I think it's a healthy nervousness. It's more of an excitement. I think any trial lawyer who says that they don't get nervous, I think probably isn't telling the truth, because it really is a lot of responsibility on your shoulders. The ultimate outcome of the case, good or bad, can really affect somebody's life. So you're carrying a lot of that responsibility. But I think, like I said, it's kind of a good form of nervousness. It's an excitement. But I think that the more trials you do and the more reps you get in, the more confidence that you develop. And so I think the confidence is ultimately like what makes it more fun. I mean, I remember in my first ever jury trial, like I was like literally shaking, waiting for the jury to come in. That doesn't happen now, but I still do get nervous. And I think that, kind of going back to what I was saying earlier about the preparation, if you take the time and have the time to prepare properly, I think that is what can kind of calm the nerves down a little bit, because you know that you've done everything you can. My goal in going into a trial is I want to lay it all out on the line. I want to know that when the jury is deliberating, I've given it everything that I can. I've prepared as much as I can. I've shown up with the energy that my client needs for me, and that I haven't left anything on the table. So the nervous energy that fuels that, I think, is a real positive, because when you're in trial, depending on how long it is, I mean, trials can last days, weeks, even months, and you're on, like, from the first thing that you wake up in the morning until 10 or 11 at night. That's all you're thinking about. And so I think that the adrenaline that comes with that nervous excitement helps to sustain you through the process. So I think it's actually a good thing.
So that's wonderful, and you mentioned the preparation, and it may sound like cliche, preparation is the key, but talking about that, and kind of, connected to connect to what you just said, I had to make a couple of keys today, right? So I asked my AI friend, where can I get the least expensive, because I needed to make 4 keys quickly. So it's at Walmart. I haven't been to Walmart maybe in 3 years. Walking into Walmart early in the morning, and so the machine, this new elaborate fast machine, asked me questions. If you pay $2 extra, you're going to get polished key, which will not get stuck in your lock. And say, let me just pay a couple extra dollars, and it does make a difference. So just like the preparation, you want to have that polished, down to the last detail. And you're doing exactly that, Andrew. When we think about behind the scenes preparation, how much preparation goes into taking a case to trial?
Well, quite a bit. And so at least in Florida, from the time that somebody gets injured until the time that you get to trial, you're looking at least 2 years. And sometimes it can be 3, 4, 5, 6 years. And so I think different attorneys have different approaches as far as the preparation. And there are some attorneys um, who will come in and like parachute in at trials at the last minute. And I mean, that's a skill in itself because you really have to rely on like the referring law firm to do all the preparation. Um, for me, in a perfect world, the preparation begins at the very outset. It's getting to know the client at the beginning, connecting with them as a human being, really understanding their story, their family life, kind of what their life has been like up to the point of the injury, how life has been afterwards. Like really connecting with them, I think is important in the early stages. And then you've got preparation with selecting of your experts and taking depositions of the defense experts, preparation and doing focus groups on your cases, developing illustrations, animations, developing themes in your trial. So I mean, it could be hundreds of hours of preparation for a trial, and it's really kind of planning out every element of trial, from jury selection to opening statement to your directing cross examinations and your closing argument. All of those need to fit together, and that's something that you really start early on in the litigation process. But I think it really begins with getting to know your client, which requires also getting to know yourself. And so I think where you and I met was at a personal development seminar. That's been something that has been really important to me throughout my whole life, but particularly as a trial lawyer, is understanding how important it is to know myself. Because the better that I know myself, the better I will be able to know my client and connect with my client, and then be able to tell my client's story to the jury so that the jury then connects to my client. So it's all about this human connection and developing that rapport that allows you to figure out what stories in my own life are similar to those of my clients, which are then similar to those of the jury, so that we can kind of tune into this like common human experience. So I think that's really where the hard work is. And the technical stuff, you can have your staff and your associates help out with, but I think there's no replacing really getting to know your client.
Absolutely. And getting to know yourself is a lifelong journey, which, us enjoyed very much. Very interesting. Yeah. Just watching yourself grow and change dynamically.
Yeah. Still figuring it out every day.
Every single day, every single moment of the day. Andrew, can you walk us through the key stages of preparing a personal injury case for trial, and just kind of, not to provide too many details, but just basic key stages?
Well, I think at the beginning, once you file the lawsuit, I think that most attorneys are evaluating the case in the early stages. Is this a case that I want to take to trial? Because not every litigation case ultimately goes there. But if you know that you want to take it to trial, you have to work backwards, at least in Florida, from what's called a case management order. And the case management order will set forth all of the deadlines. So you have to complete all depositions by a certain day. You have to hire experts by a certain day, list the experts, take expert depositions. So a lot of it is organization and management of the deadlines, and then kind of strategically selecting experts based on the facts of your case. And so I think expert selection is important early on, but that's going to be kind of down the road a little bit. The first thing that you would do is you would prepare your client for a deposition. And the deposition of a plaintiff usually in Florida at least, usually takes place within the first 3 to 4 months after filing a lawsuit. So knowing that the deposition could be used at trial and is certainly going to be used by the insurance company to evaluate the case, you put a lot of time into getting the client ready for the deposition, making sure that they know their medical history inside and out, that they've fully disclosed all of their prior treatment, all of that. So putting a lot of effort into the prepping of the plaintiff for a deposition. And then usually shortly after that, you're taking the deposition of the defendant. And in like the traditional auto negligence case, the plaintiff and defendant will be taken on the same day. So there's a lot of prep in the types of questions that you want to ask a defendant during the deposition, establishing liability, potential punitive damages, that sort of thing. And so you kind of have this split where you're looking at all of what's called fact discovery, the plaintiff and defendant, any witnesses, and then you get into expert discovery where you're building up your case, but then you're also figuring out how to attack the defense experts. And at each stage of these depositions, you're thinking about how is this going to fit together in the ultimate trial? And particularly when I'm taking a deposition of a defense expert, or anytime I take a deposition of a defense expert, I want to have it on video. And what I'm thinking about in those video depositions is I want to get these sound bites, the bite-sized clips during these depositions that I can then use in my opening statement at trial. And so I think trial preparation really begins with understanding how each stage will ultimately be a puzzle piece that you'll use for the trial at the end. There's a lot more that I could talk about, but I think that's kind of the overarching idea, is keeping in mind the end goal of trial and trying to make sure that each of the phases is geared towards use at trial. There's actually a book that just came out on this topic. It's called Depositions Are Trial by Satch Oliver, where he talks a lot about how important it is to prep your depositions with the end in mind of using them in trial. So I would recommend that to anybody who's listening, and for anybody who's kind of getting ready for their first case, thinking about trial early on really, I think, informs your strategy a lot.
Thank you for sharing that with us. I appreciate it. What are common mistakes lawyers make in preparation? I know you've been doing this for a long time, and you can kind of pinpoint these mistakes, I'm sure.
Yeah. So, well, I think that the number one mistake is not preparing enough. I think a lot of people go into trial with the idea that they're just going to wing it. And I think that there's this misconception that it allows you to be more spontaneous if you're not preparing as much, or if you don't rehearse as much. But I think actually the opposite is true. I think that the preparation actually gives rise to spontaneity and creativity, because you know the case a lot better and you can make a lot more connections in the moment as things arise. So I think one common mistake would be lack of preparation. But I think another mistake is not really thinking critically about the arguments that the other side is going to make, and kind of maybe being overconfident in your own case and not really anticipating the defenses. So that's something that I think has served me well. And something that I learned early on is when I'm preparing for trial and I'm going through all the medical records, I want to think about all of the different things in the medical records that the defense could use against me, and anticipate how I'm going to respond to that, or how I'm going to put that into context, as Keith Mitnick would say. So I think the lack of preparation and not fully appreciating the other side's perspective, kind of not putting ourselves in their shoes, is something that kind of gets people blindsided when they get to trial, because they're just not ready to deal with it. But one of the things that's really satisfying for me is when I have the time to fully prepare and anticipate all the things the defense is not going, or anticipate all the things the defense is going to do. And then we get to trial and there are all these things that I thought they were going to do, but they didn't. In other words, they didn't prepare as much as I would have if I were in their position. And that's very satisfying, because I know that at that point I'm more prepared than they are for a trial.
I love it. How important are expert witnesses, and how do you find the right ones? Do you always tend to use the same expert witnesses throughout your cases, or do you switch them out, or does it really depend on the case? And then if you, I don't know if you try cases outside of Florida, if you ever done that, have you used the same local witnesses or somebody out of state?
Yeah, this is a great question. I think this answer may vary based on your practice area, um, but I think there are some truths that would apply across any practice area. Ideally, you want to find an expert who is well credentialed and who has a good reputation and who doesn't have skeletons in his closet or her closet, so to speak. If you can find a witness that splits their expert work evenly between doing plaintiff work and defense work, I think that adds a lot of credibility. But I think that there are a lot of times when you want to be very sparing on the experts that you hire, especially in a personal injury case where somebody is under the care of a treating physician. If the plaintiff can be treated by somebody who is just their doctor, who is providing care and treatment, that person can come into trial and give expert opinions without being retained as an expert. And I think that that lends a lot of credibility, even though they are entitled to charge for their time. They're coming to court because they're being subpoenaed and they're taking care of the patient. So it's not like they got involved in the case just because they wanted to make money. They were the person who's trying to help the plaintiff get better. So what I try to do in a lot of my cases is to, when I can, rely on the treating physicians to provide the ultimate opinions in the case. If I do need to hire an expert because I need a life care planner or an economist or an accident reconstruction expert, I'm looking for somebody who has a good reputation, who, like I said, doesn't have the skeletons in his closet or her closet, but also somebody who's willing to kind of be reasonable and to concede the obvious and not go too far. I think sometimes where experts get themselves in trouble is when they don't concede what they should. So I think kind of being even keeled in that regard can be another good quality.
All right, Andrew, let's shift our focus now to the client preparation. How do you prepare your clients emotionally and mentally for trial?
So the client preparation is one of the most important parts of the trial, and it really begins with the representation at the beginning of the case where you're building trust with the client. So I think that's very important because the client has to trust you as a lawyer to guide them through the process, because many of them have not been in the courtroom before. Compared to us lawyers, we're in the courtroom all the time, but many of the clients have never even stepped foot in a courtroom. So just getting them comfortable with speaking in front of people is one of the most important parts. I think understanding their story and getting to know that by visiting them at their house, getting to know their family, hearing stories from other kind of before and after witnesses. But we actually will prep a client for a case that we know we're going to trial. We will prep a client by hiring a trial consultant, and that trial consultant will work with the client to be able to tell their story, not only about the incident itself, but also maybe different scenes from their life that we can kind of bring alive in the courtroom. So that'll be an entire day with a trial consultant that can be a really important step. But I think it's just practice and rehearsal and the building of trust is the most important thing.
Mm-hmm. I remember I attended one of these psychodrama events a couple of years ago in San Antonio, and it was mind blowing how much I learned, not even being an attorney, just like gesturing, speaking properly, creating eye contact, being silent and not saying anything at the right moments. It's truly mind blowing and so amazing. I think every trial attorney should experience that at least once in their lifetime. What's the most important advice you give clients before they testify?
So I think it goes along with reassurance. I think just reassuring the client that they're here for a reason, and it's because they were wronged by somebody else and that this wasn't their fault. And really all that they need to do during their testimony is just to tell the truth. And by the time that we get to trial, we've practiced this so much that it really should just be kind of a conversation between the attorney and the witness who's the client. And so it's almost it's as if what I'm trying to create in the courtroom is like I'm having this dialogue with my client, just like I would have a normal conversation, and the jury is kind of brought into that. And then, the defense attorneys and the insurance companies are way over on the other side. It's like they're not even part of this conversation. This is just us having this intimate conversation. And so just reminding them that they have nothing to fear. They were the ones who were in the right and they were wrong. They have a legitimate injury. And we're just having a conversation to let the jury know what their truth is.
Interesting the way you put it. I love it. When we think of strategy and decision making, how do you decide what story you want to tell the jury?
So I think it's really going to be unique to each client. We as humans, we all share common stories. Everybody's experienced love and loss, triumph, grief. So there's a lot to draw from in the kind of the commonality of the human experience. But each client's going to have their own journey. And so I think it begins with understanding that unique journey, but then being able to tell it in a way that is empowering, I think is really important. I think a lot of times plaintiffs have this idea that they need to come into a trial and just tell the jury how bad their life is and how much of a struggle it's been. And the struggle is one part of it, but what we're really trying to do is to talk about how they've done the best they can despite that struggle and how they're continuing to keep on fighting. We don't want the plaintiff to come across as a victim. And there's actually another mentor of mine named Jesse Wilson who wrote a book on this. It's called From Victim to Victor. And so the idea is the most true and resonant story for a jury to hear from a plaintiff is how they have battled the difficulties and done their best despite their injury, and how they have hope for the future despite their injury. Not the story of the poor victim who, is just so messed up for the rest of their life and there's no hope at all, and they're not even trying. I think it's been shown consistently that story just does not resonate with jurors, and really, that's not what we want as plaintiff's attorneys. We don't want our clients to give up, and so I think part of being an effective attorney is motivating the client to do the best they can despite their injuries and not become identified with this personality of the victim.
Good point. Yesterday I was listening to a trial attorney on connectionology, and she was talking about the pain of personal injury and how to pass it on to the jury. And a good point that I took from that was, she says she doesn't believe in pain scale, because a lot of doctors would ask you, once you go as an injured person to see a doctor, they would ask, what's your pain scale from 1 to 10? And so she says the reason, because it's so individual. And so she says instead she uses the question to her clients, how does it make you feel? Let's say, don't tell me from 1 to 10 being 4, 5, 6, 7, but how does it make you feel? What do you experience? What have you lost because of this injury? Emotionally, physically, mentally, so that was very interesting one. Andrew, what factors do you consider when deciding which evidence to highlight?
So one of the factors, and this is kind of an emerging theory in trial practice, is really understanding attention span of jurors. I think it's in like the psychological and sociological research, it's pretty well established that our attention spans as human beings is going down. And especially with the advent of social media and TikTok, Instagram, like all of these um, like really bite-sized clips of information where people are just scrolling from one thing to the next. What we're seeing is that the attention span of jurors is decreasing a lot. And what we have to consider at trial is that the jurors aren't allowed to have their cell phones at all in the courtroom. And so compare that to the normal day where somebody's, got their phone right by their hand all day and probably checks it, 200 times a day. The jurors don't have that. And so we need to be mindful of their attention span and how they consume media. And so a lot of the preparation of the trial is really editing down information. And I think that there used to be a an idea that the longer the trial, the more effective it was. And I think that people are kind of turning that idea on their head. Somebody who you may know, Joe Freed, is really an advocate for this idea of speed trial, and it goes to an extreme where you're taking a multiple 8-figure case and presenting it in 3 days. And so there's a lot of movement towards condensing down witnesses and not calling witnesses that you don't need, which is a struggle for a lot of us who have learned the idea that like more is always better. So I think in deciding what evidence to highlight, you want to be very mindful of attention span. You want to highlight really the most effective witnesses and not be duplicative when you can avoid it. And that's something that I've struggled with in my career, is trying to figure out how to kind of condense things and make it shorter, because one of the fears is that you don't want to end the trial and say, well, I wish I would have called this witness. But then on the other hand, you also don't want to bore the jurors with unnecessary witnesses. So I think it's a balance, but being mindful of attention span is something that's really important.
That totally makes sense. All right. Now let's imagine we are inside the courtroom. What's the typical structure of a trial day?
Well, at least where I practice in Brevard County, Florida, most of the courts will start at 9 a.m. and when they can, they'll go until 5 p.m. So, but to really understand the day in the life of a trial, it begins before that. When I'm in trial, I'm usually waking up earlier than I usually do. So maybe get up between like 5:30 and 6. Make sure I get a good breakfast. And what I've been doing lately is trying to make sure I get some sort of exercise, even if it's just walking. And then I'll have like an hour or an hour and a half where I can kind of prep for that day in the morning, and then try to get to the courthouse at least half an hour before court starts, get situated, make sure everything's organized. And then we're going from usually 9 a.m. to 5 p.m. and there's usually a mid-morning break. And you try to plan out your witnesses so that the breaks that you take are at logical times. So you might have a witness that starts at 9 a.m. and then ends at 10:30. Then you have a break from 10:30 to 10:45. Then you have another witness until 12:15. Then you take an hour lunch and come back and then do the same thing all over again. So one of the things that goes into trial preparation is creating what's called an order of proof, where you're planning out at what time during the day each witness is going to testify, and you try to estimate how long it's going to take, because a lot of the judges will require that you give them a time estimate on how long the trial is going to take. And if you don't finish in time, a lot of times the judges will declare a mistrial or get really frustrated at you, which you don't want.
You don't want that. Can you explain, Andrew, the difference between direct and cross-examination?
Sure. So direct examination is when the party who is calling a witness asks the first set of questions, which are open-ended questions, usually on direct examination. So as an example, if I'm in a trial and I'm calling my client to testify, I would do what's called direct examination, where I'm asking the client about their life, about the accident. And I usually do it in an open-ended way, who, what, when, where, why, how. So I get all of those questions out and I tell the story through my witness during direct examination. Now, when the defense attorney, the insurance company attorney, gets up and they ask questions of that same witness, that's called cross-examination. And so cross-examination is when the adverse party, in this case the insurance company, is asking questions of the witness that the other side has. And usually those questions are leading questions, meaning those questions are answered with a yes or a no. And the cross-examination questions are normally more pointed, and they are intended to kind of test the credibility of the witness. So that's the distinction. And then at the end, after the cross-examination, the plaintiff, in my situation, the plaintiff's attorney would be able to do it called redirect examination, where you're able to clarify questions that were asked on cross-examination. And so usually you have the last word with a redirect. So that's kind of how the back and forth goes.
Thank you. Now let's tap into challenges and obstacles in the courtroom. What's the hardest part about trying a case in front of a jury?
So I think that the hardest part is a couple of difficult parts. One is patience, and this might be unique to me, but I imagine other people deal with this too. Is that when you're in a trial and you're just so jazzed up to try the case, and you do your part, just having to wait through when the defense attorney does their part. A lot of times, like I'll say, I wish I could fast forward this part. Like, when they're doing their opening or they're doing their closing or they're doing their cross-examination, I just get very impatient because I want to go and do my part. So I think that having the patience and not showing the jury that you're being impatient is a challenge. Another difficult part too is after you have given your closing argument and you've turned the case over to the jury and you're waiting for the jury to deliberate, it's a very nerve-wracking experience. And it's nerve-wracking because it can last. I mean, they could come back with a verdict in 15 minutes, or they could take days to deliberate, and you just don't know it. And so the way that it works in our area is the attorneys will give their phone numbers to the court deputy, and then the deputy will call you to come back to the courtroom if the jury has a question or if you have a verdict. And so you're kind of in this limbo state. A lot of times, I'll take my team to go eat lunch or something. We try to get out of the courthouse if we can, just to kind of separate ourselves a little bit from the stress of it. But we have to stay close enough so that when they call us, we can come back. So I think that waiting on the verdict can be very, very nerve-wracking.
Oh, I cannot imagine waiting for 2 or 3 days for a verdict to come back. You can lose your mind.
Fortunately, I haven't had to wait that long, but I mean, I've waited, 6-7 hours before.
Goodness, yeah. I guess you can just breathe in and out, slow down your breathing, and meditate.
It's interesting on that topic. If the jury starts deliberating like after lunch, it's almost like clockwork that when they come back with the verdict, it's going to be right around 5:00.
I love it.
So it's like no matter how complex the case or whatever, they want to get out of there too. So it tends to work out.
It's interesting you say that. The digestion works at miracles. I used to work in the medical field, and in Georgia, here in Atlanta, we have Grady Hospital. So it's one of the best heavy trauma hospitals in Southeast. And so we used to kind of laugh. It's like tragical kind of internal joke was where, we would get most patients around 12 p.m. on Sunday. And why is because people go to church. And then after church, they, in that particular area, they go to usually fast food restaurants, McDonald's, Burger King, and they would get heart attacks. So we'd get it's like 12 o'clock. Okay, yeah. Come on in. It's crazy and amazing too. How do you, Andrew, handle situations where things don't go according to plan?
Yeah, that's a good question. Well, I think that you really have to stay focused in trial. And I think you have to go into a trial expecting the unexpected. So things never go according to plan in trial, and there's always some surprise that happens, whether it's a witness saying something that you weren't expecting, or getting a last minute motion and having to deal with that. One of my other mentors is Rex Paris, and one of the things that he says, a mindset that he adopts during trial, which I've adopted now too after having heard this, is something like this: whenever something bad happens, whenever something that seemingly bad happens in trial or unexpected happens in trial, you have to adopt the mindset that I don't know how and I don't know why, but somehow this is going to work out to make it better for me in the case. So it's going to work out to my advantage. And I've been doing that the past few trials, and it's really helped. And it's really has kind of come true, because once you affirm that and once you adopt that mindset, then you start looking for ways that you can use whatever thing that you thought was bad, you can use that to your advantage. So I think that's a really good way to deal with the inevitable, unexpected things that happen.
That's a very good point. It's all about mindset. I think that really helps probably for you personally to calm yourself down and look at it positively from positive perspective. Very interesting. And that could be very helpful tip in any area of life, not just trial. Let's move to the next step of a trial, and that is what happens right after a jury reaches a verdict.
Well, so talk about nerve-wracking. It really is pretty dramatic how it works when the jury returns a verdict. I think perhaps unnecessarily dramatic, especially in criminal cases, because they'll make the defendant stand up while the jury verdict is being read. So usually how it works is the jury will come in, like in Florida, we usually have 6 jurors. So the jury will come in, and one of the jurors will have a piece of paper in their hand. So that's the foreperson. And the judge will say, has the jury returned a verdict? And then the foreperson will say yes. And then the court deputy will come over, they'll get the verdict from the foreperson, and then they'll hand it to the clerk. And then the clerk will actually, what happens first is the judge will go through it, and if it's a few pages, the judge will read through it. And in our cases, a personal injury case, it'll have the amount of damages, and usually it's 2 or 3 pages, and the judge looks through it, and as the attorney, we are looking at the facial expressions of the judge to see if they're are they surprised? Are they smiling? What are they doing? And also how long it takes them to read it. And tell us a little bit about because if the jury says no liability, then you don't even get to damages. And so that would be a quick read through it, and then that it's no good, at least for the plaintiff. So, and then the clerk reads it and goes through this dramatic process of, all right, in the Circuit Court of the 18th Circuit in Fort Brevard County, Florida, state of Florida, just go through all of this. Question number 1, we the jury find, and it's so dramatic. And so what we're doing as attorneys is we have a copy of the verdict form that we're filling out as we go along. And so one of the first things that we're doing is we're making sure that the jury calculated the damages correctly. And we're literally adding it up on a calculator. And I've had a few trials where there's been a math mistake, and they've had to send the jury go back to add it up again.
That's the worst.
But if it's favorable, I usually tell my clients, I prepare them that whatever the outcome, I don't want you to have an outburst. I don't want you to express emotion either way. We'll obviously have a chance to talk about it privately, but so what happens after a verdict? If it's good for the plaintiff, usually there's a private meeting. Sometimes we'll go out to lunch or dinner to kind of celebrate, reflect on it. But really, anytime there's a really big verdict, the insurance company, the defendant, is going to appeal it, and so that kind of takes the fun out of it a little bit, because you're going to have to wait another year to 2 years before the appeal is resolved, and so that is something that's almost inevitable after a big verdict. Now, sometimes they'll pay or they'll try to engage in settlement negotiations afterwards. If it's an unfavorable verdict for the plaintiff, sometimes we will appeal, and sometimes we're just stuck with the verdict and we have to deal with a disappointed client. But I think if we're managing expectations well throughout, like I said earlier, if the clients understand that we can't make guarantees, we can only talk in terms of probabilities and know that we've done everything we can to ensure the highest likelihood of a good outcome, then I think the clients are usually understanding. But we try to minimize the amount of times that happens and try to get a good verdict each time we go to trial.
Wow, it's fascinating to be an attorney, to live through all of this. It's a life's drama which never ends, and it's so amazing. Wow, it's really amazing. Now let's shift gears to insurance companies. What's their real role in personal injury cases? Just kind of in the summary.
Yeah, so I think what a lot of people don't realize is that the insurance companies are the real decision makers in these cases, as far as the defendants are concerned. So if you take your typical car accident case, let's say that I got into a car accident where I rear-ended your car and you got injured as a result. You would, if you filed a lawsuit, you would be suing me, Andrew Pickett, but it would be my insurance company who's actually defending the case. So my insurance company pays for my lawyers, and they also make all the decisions about whether to settle, how much to settle for, what experts to hire. So the insurance company's role in trial is huge because they're making all the decisions. And that's going to be true in most cases. Now, there are some cases where there's not insurance involved, or sometimes in a medical malpractice case, the doctor who's being sued has to give consent for the case to settle. So it's not entirely the insurance company who's making a decision, but for the most part, they're driving all the decision making for the defense, including, like I said, the selection of lawyers, experts, whether to go to trial, what to offer, all of that.
When we think of common tactics and strategies, can you share common tactics insurance companies use to minimize payouts?
Yes, there are a lot of them. One of them that's common in the auto insurance world is for insurance companies to send a representative to people's house, like plaintiffs who are injured, to their house, like within days of the
Wow.
and so certain insurance companies do this a lot. So, and it's interesting, I think that they tend to target elderly people more, because I just hear these stories more, where insurance company comes to say, hey, we want to make sure that your medical bills are paid. We want to get you compensated. Here's $5,000 that we'll give you right now if you sign a release. And at that point, within a couple of days, the plaintiff has no idea what the extent of the injuries are. And in most cases, it's going to be much more than $5,000 as far as the value of the injury. So one tactic is to offer an early quick payout that seems like a lot to somebody, but really isn't. Another tactic is, when the insurance companies really like it when plaintiffs are not being represented. And so what they'll say is, oh, we will absolutely cover all of your medical bills, as if that's something extraordinary. But the medical bills are only one part of the damages. And so to be offered a settlement that covers your medical bills is to be offered only a very small percentage of what you're entitled to under the law. Another tactic would be just making lowball offers during the negotiation process and kind of daring the plaintiff to file a lawsuit. And a lot of plaintiffs don't want to file lawsuits because it takes a lot of time, it's more expensive. And so they just use this idea of delay. I mean, you've probably heard the term delay, deny, defend. That absolutely is the playbook of insurance companies. So that's a strategy, is making lowball offers. Another strategy is kind of blaming the plaintiff's injuries on something that's pre-existing, digging something up in their records and suggesting that everything they're experiencing now is because of some, visit to a chiropractor 15 years ago. They're also able to hire their own experts, and in most cases, they can have their own doctor evaluate the plaintiff. And so they will find doctors who will just say whatever they pay them to say. And they'll say that the plaintiff wasn't hurt, no matter what the evidence shows. And because these doctors are like highly credentialed and they're impressive, it's easy for a jury to believe them. So they hire these really well credentialed doctors, highly qualified, highly credentialed, with highly questionable opinions, based on just whatever they're paid to say. So those are some. They will. I could go on, but I'm sure you have other questions for me.
But so on this particular question, we'll have to make another episode. So we have two more episodes lined up with you, Andrew, coming up. And so I think we're going to kind of end with this. And I want to thank you so much again for sharing your insights today. Your experiences shed light on both personal injury law and mechanisms of insurance companies. And that is priceless. If someone is looking for the best personal injury lawyer in Melbourne area in Florida and around, how can they locate you?
Well, they could find me on my website, andrewpickettlaw.com. Also, Andrew Pickett Law on social media. Call us at 321-503-4014. And
what is your website? What's the name of your website?
andrewpickettlaw.com. That's AndrewPickettlaw.com.
That's great. Andrew, thank you again so much for finding time to talk with me about your transition from criminal prosecutor to personal injury lawyer and highlighting the importance of preparation and strategy of trials. You shared insights on client preparation, courtroom dynamics, and the role of insurance companies. We explored key aspects of personal injury cases and effective advocacy, which is, again, so valuable for so many trial attorneys to listen to. But before we conclude today's episode, I have one last question for you, as promised. You ready?
Okay.
All right. If you could go back and give your 18-year-old self one piece of advice, what would it be?
So if I were advising my 18-year-old self, I would say that the most important voice to listen to is your own, and that you don't have to have everything figured out, and that you should trust your own intuition, and that other people will try to give you advice based on their own fears and their own limitations. And don't make those fears and limitations your own. Trust yourself.
That's an amazing advice. And I guess those who give those advices, that includes probably your parents, brothers, sisters, cousins, neighbors, and so on. I love it. That was, again, attorney Andrew Pickett, a personal injury trial lawyer based in Melbourne, Florida. Ladies and gentlemen, I want to thank you all for watching and listening to our episode today. For more tips and tricks on legal funding and personal injury law related topics, follow me, like, and subscribe at More Injury Funding. And it's time for More Injury Funding podcast on YouTube, Spotify, Amazon Music, Google Podcasts, and all other podcast platforms worldwide. Also on LinkedIn, Instagram, Facebook, Twitter, TikTok, Pinterest, YouTube, Google Business Profile, and my website at moreinjuryfunding.com with 2 O's. I can't wait to see you, my dear listeners and viewers, on my next upcoming episode. Tune in soon for our next guest. Until then, be well. Thank you.